I had something on my lip. And my day-to-day job includes managing compliance with HIPAA, managing compliance with CMS information security. From the HIPAA side, I focus a lot on information security, but I also help with the privacy aspect as well, as our legal counsel is extremely busy. But I am here today to talk about HIPAA and where we are today, but we could talk probably for days about this, but we're going to kind of focus in on three things. And these three things are really pulled out of what's been happening in the world today in HIPAA. So the first part of the presentation is really going to just level set on where we are, what we're doing, what's happening in the industry. And then we're going to dive into three specific areas. We're going to look at enforcement with patient access. We're going to look a little bit about online reviews and some of the challenges that we're starting to see with them. And then we are going to end with cybersecurity. And I know that Janelle probably shared some information with you regarding this as well. I should probably just say that I graduated from St. Scholastica with both my undergrad and graduate degrees. So you are all receiving great degrees that are very well known in the industry. And I taught actually at St. Scholastica for about 10 years until 2020 when I started my current job. So it's kind of my background. I am here to answer questions. I will try to watch the chat as well. But if you do have questions, feel free to ask. It is important that you ask along the way as well. So let's dive in. Just a little background. When we talk about HIPAA, we really talk about three specific rules in the regulations. There's the privacy rule, the security rule, and then the newest of them is breach. As we become more electronic and we're more remote too, I think we're finding we really have seen these rules kind of interact together more than they ever have. And what I mean by that is, from a privacy perspective, it used to be like electronic health information was over here, and that was the security side, and that was managed by IT. And then the privacy rule was over here, and that's all these papers and files and everything we have, and, getting copies to people and requesting access from a patient's perspective. And then there's breach. But as we've become electronic, as our workforce has moved remotely, these really intertwine in ways that I think people don't recognize or didn't maybe assume that they were going to. So when I talk about the fact that I deal a lot with privacy stuff, part of that is because our remote employees, it might be a security incident, but it ultimately impacts the privacy compliance that we have to meet. On top of that, we also have state law, which can complicate things as well. So just so you know, the way the HIPAA regulations are written is if the state law is either more strict or provides greater right to the patients, then you have to follow state law versus federal law. Ultimately, the goal would be that you would follow both state law and federal law, but sometimes you can't, right? Sometimes it's contrary, and then you have to work with the federal government to determine. But just to give you some examples, in California right now, if a patient requests access to their health information, you have 30 days to respond. In California, you have 15 days, which means the patients have greater rights because it's a shorter time frame. So you'd follow California law versus federal law. In Minnesota, here we have what's called the Minnesota Health Record Act. For the most part, it's in alignment with HIPAA, except for under HIPAA, if you're releasing, using or disclosing health information for treatment, payment, and healthcare operations, at that point in time, you do not need a authorization from the patient. However, the Minnesota Health Record Act really says anytime you use and disclose health information, you will need a consent. So then again, that's greater rights. So you'd follow Minnesota state law. So those are just some examples that we see. We are seeing new regulations popping up at the state level as well. So we have to be aware and kind of manage to those as well. And this is just a trajectory of where HIPAA's been. It's not new. I do a lot of education on HIPAA, and that's what I tell people. This regulation was actually enacted back in 1996. And this is kind of the path that it's taken. And if you look on the right-hand side, there's a big question mark. Part of the reason for that question mark is there was proposed rules in the end of 2020 in the previous federal administration, and then proposed rules you don't have to comply with. The intent is to go out to the industry and get feedback and, kind of get real, because again, the people writing these regulations aren't necessarily the ones practicing in healthcare. So the intent of the proposal is to get feedback back and then determine how you finalize the regulations. So that's been out there since like end of December 2020. And then I guess it was officially published as a proposed rule in January. However, nothing's happened. So this is kind of a wait and see. We could see finalization of these regulations. We could see it just sit and fizzle. So kind of a TBD on that one. In addition, one of the other things we're seeing a lot of is there's a lot of regulatory initiatives from the federal government perspective. Part of it is the last time HIPAA was updated was in the HITECH Act of 2009. And there was some requirements that came out of that haven't been addressed at this point. So not necessarily regulation changes, but requirements as far as having to do investigations into potential changes in the regulations. So obviously we just talked about the modifications to the privacy rule, which was the proposed rule that came up. On the top right-hand side, you'll see the recognized security practices, and RFI means request for information. So what they do with these recognized security practices, or anytime there's a request for information, it's kind of before that proposed rule where they're trying to do some investigation to determine what it actually is the industry doing and how could we build regulations based on what the industry was doing. So they're doing that a little bit for recognized security practices. We're going to talk more about that in the cybersecurity component of it. They're also on the lower right side, you'll see the civil monetary or money penalties. So basically what they're looking at, and this again came out of the HITECH Act, is they really are saying when the federal government is collecting money because of a HIPAA violation, so basically when they're assessing a HIPAA fine, should that money stay in the federal government or should some type of settlement go to the individuals impacted? So if they collect $1.2 million, should the 10,000 people that were impacted be given some of that money? So that is really just in that investigatory stage on do they build regulations? And again, that's coming out of the HITECH Act. And then the last one on the right-hand side, really looking at how they align patients in substance abuse, privacy and security regulations with HIPAA more, how they increase the ability to coordinate care while protecting confidentiality. So for substance abuse organizations, there is a little bit more of a stricter requirement around privacy and security of health information. And because of that, it gets a little confusing, and there's sometimes barriers go up with sharing information, which maybe it should because it's more sensitive. So they're really just in that investigatory stage on how do we really try to align with the HIPAA regulations. And we're going to celebrate the 20th birthday of the, not the enforcement, but the HIPAA privacy rule. So I will tell you, this makes me feel kind of old because this is when I was going through school. So the privacy rule will celebrate 20 years. And you think, when I think about this, you think, oh, why aren't we good at this yet? Why haven't we figured out how to really apply the HIPAA privacy rule in the right way? Why is there so much enforcement? And I ask myself, and that's why I bring this up, because 20 years later, we're still struggling and we're still figuring out. And I think from an HIM professional's perspective, that means there's still a lot of opportunity for all of us to get in there, help organizations, and really support patient rights, which I like because I like to help organizations and I like to be able to support patients and patient care as well. There also has been some new and updated HIPAA guidance. So one of the things to remember with HIPAA, and as you go out and start your, professional life, and if privacy and security is something that you're either going to be doing or interests you, the regulations don't change often, as we've seen. However, what happens is the federal government will publish guidance. So the intent is that they will publish guidance to help organizations implement the regulations. So it doesn't change the regulation, but it changes the expectation. I hope that kind of makes sense to everybody on, what the difference is, but it really focuses on, okay, here's the regulation. This is what we expect. So there was recently, actually in December, they posted a bulletin on online tracking technologies. So what this is focusing on is if you have some type of tracking technologies on your website where you're tracking traffic who's coming to your website, IP addresses, all this kind of stuff, and then you're taking that and giving it to marketing, or you're using that information inappropriately, then you may be found out a HIPAA complaint. So they talk about online tracking tools. We're just diving into this at my organization right now, so I don't have a huge update for you on that, but it is very interesting because, you know, if you're tracking activity on who's coming to your website, and then you just, you know, you release that to, you know, maybe you are an OBGYN organization, and all of a sudden you release that information to, you know, an organization that sells, you know, post natal breast pumps, whatever it may be, then that could be considered an unauthorized disclosure of health information. So kind of an interesting perspective. There's some guidance on HIPAA and audio only telehealth. With the pandemic, there obviously was some guidance on telehealth, but there's areas within the United States that cannot support video. So they really published some guidance on what happens when you have audio telehealth, really focusing on right of access, which we're going to talk a lot about, and then new security practices, which we're also going to talk about under cybersecurity. So lots going on out there. I think it's kind of exciting. Just looking at kind of what happened through 2022, we saw another large year of data breaches. One thing to remember is the federal government only publishes real-time data on the over 500 individuals impacted. The under 500 is published like a year later. So right now we're waiting for the data from 2021 to be published, which should happen hopefully soon. 87% of those data breaches are being investigated by the OCR. So the OCR is the Office for Civil Rights. They are the enforcement arm of HIPAA. So they investigate all the data breaches. Cybersecurity continues to be the biggest threat from a perspective of data breaches, which makes, I guess, if you start to think about it, which makes sense because these are the data breaches impacting over 500 people. In fact, 78% of the data breaches in 2022 were due to hacking and IT incidents. So that this could be phishing, this could be someone getting into your account, this could be someone, you know, ransomware is an example of some of the stuff that we see happening. And I know you're probably thinking, I'm never going to manage the security side of the world. And I always tell people, even though I'm an information security officer, I'm not a security architect. So I always promote being being over the HIPAA compliance when it comes to security as well, because one of the things that we in health information are really good at is being a liaison between the legal side, the information technology side, the operations side, and then being really able to understand and apply regulatory aspects. And I think that's why, you know, we do make a great security officer as well. But this is just an image of where we've been over the last 10 years since we or 10 years, what am I talking about? 15 years almost since we started tracking data breaches. And you can see that we, you know, held steady, but in the last 5 years, we've definitely seen a big increase in the data breaches that are over 500 individuals. And then this is just the ones focused on hacking and IT incidents. So I always tell people, if I would have showed you this, obviously 5 years ago, the biggest risks to the organization were the loss and theft of equipment. But now it's hacking and IT incidents. So it's almost like the loss and theft of data that we're starting to see. Now, why is this happening? One, I don't think the healthcare industry was as prepared for electronic in the way that we did as some of the other industries, such as banking or, credit card, et cetera. I think the other thing is some of those other industries are required to have, expectations. They're actually audited from an aspect of you have to prove to us that you have this certification, which tests all your security levels. We don't have that necessarily in healthcare. There are ways to get certified in IT security, but they're not mandated to be a healthcare organization. And, I just think once a hacker sees where the opportunity is, any criminal, a cyber criminal or any type of criminal, they're going to go after that because they know they can be successful. So that's super fun. I just wanted to dive a little bit into enforcement, which is going to bring us to our topics of patient access and then online reviews. So enforcement we saw an increase. Actually, we saw a large year. And part of me thinks that, did they do this on purpose? Because in 2022, they saw 22 HIPAA fines. So I'm not sure if they did that on purpose or not, but kind of coincidental. But 19 of those 22 HIPAA fines were actually due to non-compliance with the patient's right of access. And I want to talk a little bit about why that's important to understand. Is in the past, HIPAA enforcement and like the assessment of fines really happened to organizations that had data breaches, or, where there was hundreds of thousands of, people losing their information or being impacted by a data breach. And you saw these big multi-million-dollar fines happening. With the patient right of access morph into the non-compliance world, this isn't multiple people being impacted. Actually, a lot of times these patient right of access are just one or two people, normally one, who can't get access to their records, who file a complaint with the federal government, they open an investigation. So when I go and work with organizations and do education to them, I always say, have you ever had a patient complain about services? And I have never been to an organization that says we have never had a complaint, right? Because sometimes even if you're the best person in the world and the best organization, your patients are still going to complain. It's just the world we live in. And so that is a shift. This is no longer data breaches. We're telling on ourselves, we get a HIPAA fine. This is a patient's not happy with something. They lodge a complaint with the federal government. We're investigated, and now we have a fine. One of the other things that changed this year, and I thought it was kind of interesting, is 7 out of the 22 fines were in dental offices. We haven't seen this. Actually, I think prior to this year, there was maybe 1 or 2 HIPAA fines that were even ever assessed to dental offices. So the other thing is the other, 13 or whatever the math is, 16, 15 fines, they're not necessarily large integrated healthcare systems. This is what else we're seeing a morph to, is they're really small organizations. They're podiatry offices or ophthalmology, dental, home healthcare, different things like that, that we're seeing these fines assessed to, which is impacting, I would say, how people are looking at HIPAA, because there's a lot of people in the industry that say we're never going to get caught. It's never going to happen to us, but this tells us everybody has to be aware. The other opportunity I think that exists is that, dental offices, podiatry, ophthalmology, single provider clinics, that kind of stuff, they don't have actually a business need to have a full-time privacy and security person. Maybe they outsource all their security. So it's like, how do we continue to support these organizations when there's not a need for someone to be there full-time? So, just something to think about as you kind of look at this. But the other aspect that we're starting to see trickle up again is, disclosure of health information with patient online reviews, and we will dive into that as well. All right. Oops, sorry. I don't know why that's on there again. I think I hit backwards. Excuse me. So a little bit more of the breakdown of the fines. 19 were due to patient access. I talked about that. 1 was due to improper disposal of patient information. 1 was due to an impermissible disclosure, which was basically a response to a Yelp review. And then 1 violation was like privacy and security and breach. And so that was like a whole big violation of everything in between. And that organization actually got a multi-million-dollar fine. One of the things I should say too is in 2023, there actually has been 2 HIPAA fines already. We're going to dive into both of them because they're pertinent to our topics that we're talking about today. But we've had 1 for patient access, and then last week, there was 1 for a cybersecurity incident as well. The other aspect of enforcement, just to know, there is the opportunity for the state attorneys general, I always say that wrong, to also enforce HIPAA. So this was given to them under the HITECH Act. And so they can actually come on behalf of the citizens of the state and assess a HIPAA fine on behalf of those citizens at the state level. So if you have a bad data breach or something happens, you could potentially be fined by the federal government. You could potentially be fined by your state attorneys general. You could potentially have a civil lawsuit as well. So there's a lot of different ways. And I always tell people, I don't tell you that to scare you. I tell you that so you're aware of that. And it's important for all of you to know that as well. When the other thing to remember though, when they're assessing a HIPAA fine, so first off, let's just say 22 fines out of how many covered entities and business associates that there are. It's like a needle in a haystack, right? I mean, there's hundreds of thousands of organizations that are considered just covered entities alone. But they also consider, they don't necessarily just assign a fine to assign a fine. Can I just take 1 second to respond to something? I'm sorry, this security incident.
Not a problem.
Okay, thank you for that flexibility. So the considerations that they also consider is, okay, how many people were actually impacted? What is the practice history? Is this their first violation? Are they a continual, violator of the HIPAA regulations? Whether, potentially could this jeopardize a, oh my goodness, my phone is listening to me, y'all. Could this jeopardize any type of civil suit that's out there? But I think the ones on the right-hand side are important as well. One of the things they don't want to do is, assess HIPAA fines that cause organizations to close. And then because of that, then they impact the ability for people to receive care. So obviously, being able to receive care if you're in a rural community and there's only one provider, and they assess a $20,000 fine that closes the organization because they can't pay it, then you have a whole bunch of people that no longer can have access to healthcare. So they look at all of that before they actually assess the fine. In addition to federal fines, just so you know, we don't see this a lot, but there is civil fines, criminal penalties. So that means me as a person can be held liable for HIPAA if I maliciously, or maybe not maliciously, actually violate it. I will tell you, this is not very often that we see these, but what does happen when we see these, it's because really that yellow line is where there's malicious intent. So this is, for example, when someone steals information out of a health record and then sells it to the dark market for identity theft or something like that. So we don't see a lot of the top two. If someone does, I mean, this does happen, so I don't want to say that it doesn't, but it's normally because someone is literally stealing information and then selling it for personal gain. So just some things as I look into what's going to happen and kind of where we're going to have our conversations now, there's definitely going to be a continued focus in cybersecurity. There's going to be an increased threat to us. I think I just read 2 days ago that a East Coast hospital had to divert all their patients and actually cancel some elective surgeries because of the fact that they got ransomware and weren't able to properly care for patients. So we're going to, when we talk about patient safety, cybersecurity technology all impacts patient safety. So it's important that we make sure that our organizations know about that and that we talk about what happens when something happens. Potential changes to HIPAA, we're definitely going to see, potentially some regulatory changes, some really looking at information sharing not being a barrier is the ultimate goal of some of that. And we're going to see the continued increase in state law. State law is really, intended to protect the citizens of that state. So that's why they're really looking at how can we maybe HIPAA sets the floor, I always tell people. So how can we make greater rights for our patients or hold organizations more accountable? A lot of states, I should say, are really aligning with GDPR, which is the European Union's privacy and security regulations. And, that's a fun thing to note too. If you ever want to learn more about, regulations, it's not just unique to the United States of America. The European has the GDPR. Canada has something called PEPIDA, PEPIDA. It's very similar to HIPAA, but that's their version. Australia has their own privacy and security regulations when it comes to healthcare. Asia has some too. So there's a lot of different ones out there. So it's kind of fun if you're interested in that. And I only say that because there's a lot of opportunity. You know, our industry is really becoming a global industry. It's not necessarily just the United States anymore. In fact, I was just, perusing through some LinkedIn jobs that were popping up, and a lot of them are looking for that, knowledge and expertise or ability to work internationally, and not necessarily fly internationally, but remotely support the ability for the organization to work or internationally. So just kind of some fun things out there as well. Any questions on that before we dive into patient access quick?
I have one.
Yes.
So is there like a main difference between each country's version of HIPAA? Like, do they each prioritize on a different thing, or
Yeah.
what differentiates them?
I think the foundation is the same, meaning the goal of the regulation is the same. I think for example, GDPR, it is much more strict than HIPAA. So not only, and it actually applies to every industry and not just healthcare, but not only do you have to protect patient rights and tell of a data breach happening, but they take it a step further and they say, if a patient wants you to forget about them, you have to be able to support that. And what that means is maybe you get rid of the ability to access that information by everybody, and you I'm going to say soft archive it or something like that. So they have greater regulations. I would say the one thing that's probably a little bit different with HIPAA is there's a lot of patient rights that we give patients, and that necessarily isn't the same across the board either. But I think the intent and the goals are basically similar. The one additional thing to remember, I think, too, as we think about other countries, is our healthcare payment system in the United States is very different. When you have socialized versus we have obviously an industry where we're all paid by health plans for the most part, even at Medicare and Medicaid, right? When you're in a socialized healthcare plan, such as Canada has, where all their citizens receive the same healthcare, then it might look a little bit different on how we protect health information in the ways that you can use and disclose health information. So great question. I have to tell you, I'm not an expert on all of it, but I personally enjoy, I think it's fascinating. I do have a book. I'm trying to teach myself more about the GDPR, just because I think, one thing that's different with the GDPR, and again, that's the European version, is that it's not necessarily just in Europe. How the regulations are actually written is, if you're actually maintaining information on behalf of European citizens, then you should really be following GDPR, which in the United States, clearly we are, right? We have people from the European countries come over here and probably receive healthcare or live here permanently. So there's still some trying to figure out how does that apply, but a lot of organizations are starting to put in requirements around the GDPR, just because they do support either international, for example, Mayo Clinic might have a lot of people coming from international, or because they know they service a lot of patients that are, immigrants or come from other countries that are citizens of those countries, that we need to comply with that as well. Good question.
Thank you.
I hope I answered it. I kind of feel like I rambled, but.
No, you did. It made sense.
Okay. Any other questions? All right. Well, let's go ahead and dive into patient access. So kind of two parts to this presentation. The first thing I'm going to take you through is a little bit with what we're seeing with the enforcement aspect. And then we're going to talk a little bit about the regulations. So in the fall of 2018, the government actually started a grassroots campaign, and they're really focused on trying to get patients engaged with their health information, which is music to my ears, and I'm sure to Janelle's as well, and hopefully to all of yours. But they're really saying, patients, you have a right to this information. It's powerful medicine. Access to health information is your right. Get it, check it, use it. They put out a bunch of, infographics, and they've recorded videos. They're all out on the Department of Health and Human Services YouTube, or you can go to this. I always just Google, get it, check it, use it. because it comes up fast. Information is powerful medicine. So what they're really trying to do is encourage patients to ultimately get their information. I think we're seeing a little bit of a, generational aspect where, I'm going to use my parents. They don't want, I laugh because they're so funny sometimes. They don't understand that they can get access to their health information, right? They're like, "What, Danika, that's the doctor's information." And I'm like, "Yep, but you can get it. They're snowbirds. They go back and forth between Minnesota and Arizona." And I'm like, "You need to take it with you. You need to have it." So we've worked on that. And then I have children that are 14 and almost 16, and they're like, "Can't you just go print that offline?" So it's kind of a generational thing too. But our health information is our right. And sometimes health information is wrong, and we have to check it to make sure it's accurate, to make sure it's ours. And, it's beneficial if you use it in continuity of care. I'll just use an example. And this happened literally Tuesday. My youngest had an appendectomy in November. And as part of that, she, tested positive to COVID, which was really interesting because she was completely asymptomatic. But one of the things they said is when they did her CT scan, they saw like potentially pneumonia in her lungs. So she's been sick this past week, and I brought her in just to get checked out. And it was to literally the same healthcare organization in Minneapolis. And I said, "Well, can't you just get access to her records and see?" And they said, "Even though we're the same company, we have two separate electronic medical records." And so that's like if I would have just had my packet of information, I could have just showed her what the results were for her CT scan, but she didn't even have access, and they're the same literally entity because they have two different EMRs. So it's kind of an interesting thing that happened, but that's really the goal, right? We want to help our providers, and it doesn't mean it's our main responsibility, but we do want to help them if we can with our, bringing our records with us. But one of the things we're seeing is, patients just aren't being supported ultimately. And, this was in the end of 2022. There was 42 corrective action plans with monetary settlements, which we've now seen 41 at the end of the year. We've now seen 42. But one of the things that's interesting is they're publishing sometimes 3 or 4 settlements in one day. One day they actually published like 11 in one day. So what they're trying to get out there is, hello, healthcare industry, let's support our patients. It shouldn't be hard to get a copy of your health information, and you shouldn't have to have your patients jump through hurdles. So this is just an example of one of the cases, and why these are being bubbled up to the federal government is on May 8th, a patient requested a copy of her complete medical records, which under HIPAA, they can get what's considered the designated record set. HIPAA term basically means all billing records, right? So that's basically what it is. It could mean x-rays, it could mean actual images of films, it could mean radiology reports, emergency room, op reports, anything that's in their record that's used to support their care, they can have access to. On August 8th, the patient didn't hear anything back or did not receive a copy of their records, so they actually filed a complaint with the federal government. And then on October 12th, this just happens to be a dental office, actually produced all of the requested records. That was 5 months later, right? So this is why we're seeing this, because under HIPAA, you have 30 days, and ultimately you have one time you can extend it for 30 days. So at most, it should be 60 days for a patient to receive a copy of their records. 5 months is unacceptable. And that's why this organization ended up with a compliance violation and a HIPAA fine. But the OCR director, this is the person that really oversees all the enforcement. Person is appointed by the federal government. So usually whoever the Secretary of Health and Human Services appoints a OCR director. This person just started. So this is our newest one, Melanie Fontes Rainier. And I think this is a powerful message, is these 3 right of access actions send an important messages to all dental practices. And I think you can say all organizations, that covered entities have to comply with the HIPAA rules to ensure they're following the law. Patients have a fundamental right under HIPAA to receive their requested medical records, in most cases within 30 days. I hope these actions send a message of compliance so patients don't have to file a complaint to get a copy of their medical records. They shouldn't have to copy it. We should be able to support them, is basically what she's saying. Oops. The other thing I think is interesting to look at is the federal government produces information on kind of the top issues every year that they're facing as they do these investigations. You'll see issue number 1 is always going to be impermissible uses and disclosures. That's data breaches. But you can see the thing that's popping up, and if this is 2018 to 2021, is the patient's right of access. It just continues to, morph into a bigger issue. So it'll be interesting to see what 2022 is. But I think this is an interesting perspective too. So this is the top bullet point on each of these is the total HIPAA fines. The second bullet point under each of the years is the number of patient access fines. So in 2019, 2 out of the 12 were patient access versus, 2022, and I haven't updated this for 2023 with the fine that was just done last week. But you can see that a big percentage, we're seeing an increase of the percentage of number of HIPAA fines are actually due to patient access. What this tells me is healthcare organizations, this is where you should be focusing your energy on right now. So I just want to, so I dove through kind of all the different resolution agreements that are published, because all this is public data. And I pulled out 4 or 5 specific things that I saw as kind of, reoccurring themes when it came to noncompliance. So the first was just not responding in that timely fashion. So again, you have 30 days with one 30-day extension. A lot of times, I would say a big majority, they just flat out didn't respond at all sometimes, or didn't respond within those 30 days. The second is failing to provide the protected health information in the requested format. So patients do have the right to kind of drive the format they want to receive the information in versus electronic versus paper. And so there was a lot of them where they didn't respond in the correct format. Failing to provide all requested documentation. So if you requested any and all and they only gave you an office visit, that was an issue that continued to be in play. Again, the regulations say as long as it's part of the designated record set, the patient has access to get a copy of all of that. Failure to provide a copy of records to the requested recipient. And this is a really interesting one. It's actually caused a lot of confusion. So under the patient's right of access, there is the ability for the patient to direct their information to go to another organization, or to an organization or to another person. So this is where HIPAA maybe gets a little confusing. So there's patient's right of access, which we're talking about now, and then there's use and disclosure of health information. Use and disclosure of health information is really when you're intending to disclose it to a third party. So that's where you'd have your patient fill out that huge form and you disclose it to whoever they're requesting. When they came out with the newest guidance under the regulations for patients' right of access, they have this whole section on the ability for the patient to direct their health information somewhere. The challenge with how this has been interpreted in the industry is there are some people that have taken advantage of it. One of the areas that we've seen is attorneys. So rather than an attorney requesting a copy of medical records that would fall under the use and disclosure of health information, they've now rewritten things to have the patient direct health information, and therefore they can't be charged the highest amount. So this actually is in the court system right now. There's some information. A company actually went after and sued the government to try to get this resolved a little bit. So there's some good information if you look up the patient right of access, but this is actually has caused quite a bit of confusion in the industry and frustration, I would say. And the last thing I've seen is impose a copy fee. There's very specific regulation guidance on how you can charge the patients for the right of access, again, which is different than disclosing to a third party under the use and disclosure regulations. So, when they're charging a patient too much money, that's not considered reasonable and cost-based, they can be found out of compliance with that as well. So that is kind of the top areas that I saw as issues. So what I thought we could do before jumping into our next conversation part is really look at what is the regulation. In my opinion, it's relatively simple. I know sometimes when regulation is simple, the operational aspect of it can be harder to implement. But from a regulatory standpoint, it's relatively simple. Covered entities must provide an individual with access to their health information if they maintain it. Individuals have the right to inspect or obtain a copy. Now, inspect doesn't mean that they get a system, or I should say that they get a username and login and can access your system. What inspect is really focusing on is they have a right to review what the content is and inspect the information, or they can get a copy of it. And they also have the right to transmit a copy to a designated person. So this is that I direct it to someone part of the regulation. So individuals have a right to access their health information as long as the covered entity is maintaining it, regardless of the date it was created. So if it was created in 1925 and it's on microfiche and you have to go find the microfiche and print it off, but you're still maintaining it, they have a right to access it. It doesn't matter the media type. So if it's paper, if it's electronic, if it's microfilm, microfiche, if it's scanned and stored as PDFs, whatever it is, if it's on site, if it's remotely remote archived, as long as you're maintaining it, you have to be able to produce it. And, you know, they also have a right of access on where it actually originated. So if it originated at Hospital A and Hospital A is still in business and they're still maintaining it, they have a right to access that from the organization. And they have again, we talked about this, is they have access to what they consider the organization's designated record set. It is considered different than the legal health record, just so everybody knows, but the designated record set is really just all the medical, clinical records and billing records about an individual maintained by the covered entities. So it could be, as I told you, lab reports, emergency room, office visit, dental visit, you know, your optometry testing, anything like that. It can be to support patient care. From a health plan perspective, because again, health plans are covered entities under HIPAA, it's really all the enrollment information, payment, claims adjudication. If they do medical or case management, that would also be considered part of the designated record set. And this third one is interesting. So all records that are used to make decisions about individuals. So what this one is really focused on is if you receive information from clinic A in your, you know, hospital C, and you use that information to actually treat the patient and make clinical decisions, what this is saying is that actually becomes part of your designated record set, even though it didn't originate at your organization. So that's really what makes up the designated record set. So what does it not include is a good question too. It's not the metadata, right? So it's not Danika Brinda accessed this record on this date and time. That's not considered part of the designated record set at this point in time. Maybe if you have some type of like incident report, so if a patient falls out of bed, that is normally not considered part of the incident report itself, is usually not considered part of the designated record set. Obviously, there would be care information, progress notes, potentially surgery, whatever it is that resulted, that would be part of the designated record set, but the actual incident report potentially would not be. So that's really kind of, you know, what are some examples of what's not. The other two things that we have to remember too is that patients don't have a right necessarily to their psychotherapy notes. And what psychotherapy notes are, I like to think about them as basically like the jotting down of notes by a therapist when they're in with a patient. So they jot down notes and then they take that information and actually type it up. Those psychotherapy notes are not considered part of the designated record set as well. And then any information from like a civil, administrative, any type of, you know, investigation or lawsuit would not be considered as well. Again, 30 days from the date of data discovery. Listen, living in the breach world, 30 days from the data request, but you'll see that statement of without unreasonable delay. So that means if you could produce the records in 15 days, you can't wait 30 just because you want to. You would produce them in the time frame that's reasonable for your organization. You are allowed one 30-day extension. However, you have to write, it must be in written format to the patient, and it has to be within the initial 30 days. So, you know, on day 25, I can write a letter to the patient and say, you know, dear Danika, we are unable to access your request because your records are stored off site. You can expect to get your records in the next 30 days or whatever it may be, but it has to be within that first 30 days that you notify the individual. the other thing that's been interesting about the patient's right of access, and not necessarily from a regulatory change standpoint, but really from an expectation or the guidance, is healthcare providers may not impose unreasonable measures on an individual to access their health information. So what are some examples of unreasonable measures? If I'm an individual and I want you to send a copy of my records to my home address. So I call and say, hi, this is Danika Brinda. I'm a patient. I would like you to send a copy of my medical records from my most recent visit to my home address. What the federal government says is there's ways to verify the person is who they are. And if you're sending it to the address on file, then you shouldn't require them to come in person to show their ID to you in order to receive their records. So what you can do instead is say, okay, can you confirm your name? What's your date of birth? What's the last 4 digits of your social? And let me know your home address. And if that's everything that you have in your system, from a verification standpoint, you should be able to just send the records to that home address. You're not sending, if they say, oh, my home address is this, but I want them sent to this other location, then that might be an example of when you need them to fill out a release of information form. But if they're sending them to the home address, you can verify that. You can't force individuals to use the web portal. Not individuals will have access to the web portal. Again, there's parts of the United States that don't have access to internet, so you can't require that. You can't require, this is an interesting one that's really created some angst in the industry as well. But you can't require an individual to complete an access request form that would create any unreasonable delay. And from a standpoint of documentation, I personally like the fact that a patient would fill out an access request form. Again, maybe not the same as the release of information form. And for those of you who are members of a HIMA, they have kind of a sample patient access request form and then a sample use and disclosure of health information. So you can kind of see the difference on maybe what you would request. But they can't, it cannot do is create barriers. So you can't say, Danika, I would love to send you your information, but before I do that, I'm going to mail you this form and you have to mail it back to me. There's other ways to get that information. You can have them send you an email. You can have them, fax in a document that just says, I, Danika Brinda, request my records be sent to my house. There's different ways you can request that versus actually making them request the access documentation. All right. Whoops. So in responding to this to the health information patient access reports, you must provide the individual with access to the protected health information in the format and form they requested. What this is saying is if I come in and I say, I would like a copy of my medical records on a USB drive, please. The organization, if that is readily available to the organization and they can produce it that way, then they have to produce it that way. If you walk in and say, I would like a copy of my medical records on this USB drive, you can say no, because I wouldn't put this USB drive that you have no idea what's on this in any computer, because in my opinion, that creates risk for the organization. But you can say, Danika, we can't use your USB drive, but we can produce it on a USB drive and give it to you, and you can combine them. So the healthcare organization does have some flexibility. Now, you also don't have to go produce or buy new equipment. So if a patient comes in and says, I want this on my USB drive, and you say, oh my goodness, we can't do that, we only have the ability to burn it on a CD, you don't have to go buy the functionality to burn it on the USB drive. You can negotiate. I like to kind of think about it as negotiating with the patient to say, we can't do it this way, but this is the way we provide electronic access. Would this work? And if they say no, you can always default to paper. From the federal government's perspective, United States Postal Service, so mail and email, are always considered generally usable or producible. So if you have the ability to email, then you have the ability to produce it electronically, is basically what this is saying. On the right-hand side, an organization may provide the individual with a summary. So when would this happen is a prime example. For those of you who work in health information or have, visited a health information department, even though we're electronic, we still have a lot of paper. And sometimes I think even more paper than we did in the past. But if someone, is in a hospital for 10 days and they want a copy of their entire record, honestly, it could be like 3 or 4 reams of paper. And I'm not kidding. So rather than, the entire record, maybe you provide a summary and you can negotiate with the patient on that as well. They have to agree to it in advance. They have to agree in writing. And then if there's any fees, they would also agree for that as well. So just kind of some other patient access. A little bit more, on the form and format of the papers. So again, request for paper copies. Obviously, if it's on paper, you can produce it on paper. However, if the patient requests it electronically and it's on paper, if you can change that paper copy to an electronic copy, then you should do that and it would be readily producible. So, these new copiers we have, they're fancy. They're like scan, copy, fax, all in one. If you could scan the paper, send it as a PDF to an email, and then get it to the patient electronically, and that's what they want, you should be able to do that. From an aspect of electronic copies as well, if an individual requests an electronic copy that is maintained in electronic format, you have to produce it in electronic format. Again, that negotiation comes in if you don't have the functionality to do how they wanted it. You do have the ability to say, we can't do it here, but we can do it this way. And a little bit more on electronic copies. If an individual requests an electronic copy that you maintain, obviously you have to provide it. If it's not readily producible in electronic format, you can also agree upon an alternative format. One of the things I will say though, which is kind of an interesting perspective, is the other thing that the patients have a right to do from the electronic standpoint is they have a right to receive it as a copy. We saw that's considered readily producible through email, and they can actually request that I always say if you're going to send it through email, it really should be encrypted. However, the patients have the ability to say, I don't want you to put any of that stuff on there that makes me log in to get access to my, records. I just want you to send it via email, basically unencrypted or unsecured, if you want to think about it that way. They can do that. However, they just have to sign off on physical paper at that point in time to say, I understand that I requested it in an unsecure manner and that it won't be protected once it leaves the organization. A little bit more about the right to direct. Again, what the statement is the individual has a right to direct healthcare organization to transmit PHI to another person or an entity. However, in this specific scenario, it has to be in writing. So this is where they can't just call and say this. It has to be in writing and it has to be signed by the individual requesting it. And it means like an actual signature or a true digital signature, depending upon if you use a digital request form. And it must clearly identify and designate that person and where to send it. A little bit about fees, because this has caused quite a bit of a ruffle as well. And there's actually documentation out on the patient's right of access regarding some fee structure. But in the past, one of the barriers to getting access, and again, one of the goals is to reduce barriers, is to make sure that an organization is not, charging too much for records. Basically, what the newest guidance is you can only charge for the actual cost of getting the records. So one of the things we see is like, in Minnesota, you can charge $1.27 per page that you copy of a medical record. When it's for patient access, you cannot charge that amount. You can only charge what it actually takes. So if it takes you 65, or if it costs 65 cents for you to produce a piece of paper, then that's what you would charge. But if you say it costs 65 cents, then you have to be able to prove it. Basically, you have to be able to prove the labor, the supplies, the postage is something you can talk about, or if you're preparing the summary, you can also use that. However, this can get pretty complicated, right? So if you're trying to figure out how much it costs to produce a page, it takes time and effort, and a lot of times we don't have that time and effort in healthcare. So a lot of people are just using a flat fee or they're not charging at all. But you cannot charge any costs for verifying the individual, for, preparing documentation, for searching and retrieving records. You can't try to recoup capital for your systems and use it for maintaining systems or use it for any other costs. It has to be the actual fees that you're charging them. One of the things, just to kind of talk a little bit about this more, the federal government has basically came out and said, if you're going to charge for an electronic copy of records, it shouldn't cost more than $6.50. So a lot of organizations are just using that amount if they're going to charge an individual, because of the fact that it is already out there and it's, documented. So you can, though, this is outside for use and disclosure, for like disclosing health information to an attorney, you can actually charge more than the, excuse me, I'm tangled. You can charge more than the actual just reasonable based cost. And then always remember, you have to verify an individual too. So you have the right as the healthcare organization to verify the individual is who they are. You can do it orally or in writing, whatever policies are, but you cannot make verification be a barrier. So you can't say, Danika, I'd love to send you your records, but you need to come show me your government issued ID or I can't give them to you. That would be considered a barrier. There's other ways, again, to verify. And patient portals, just so you know, are considered a way to verify. So if you do have a process where you can request records through a portal, you have, like, using a patient portal is verified because usually you have to authenticate in. So again, patients have a right to make a complaint about your organization. So, compliant. So we want to make sure that your organization is compliant. So how do you make your organization compliant? So there should be written policies and procedures. You should have a clear process for patient access, really making sure you have your patient access also defined in your notice of privacy practices is required. I always say date patient requests when they're received. So whether it's orally, whether it's on paper, whether it's an email, which is nice because it timestamps it, make sure that you document it and you have a way you're documenting it, either within the clinical record or some other way so you can track that you're compliant. Make sure that you are individuals know who is responsible, I should say, for processing requests, and then train all workforce members. And I always tell people this is important because, patients don't know necessarily who to request their records from. So they might ask the doctor, or they might ask, their nurse as they're being roomed. So everybody needs to know the process on the patient's right of access and where it goes when a request is made. And then I would say audit your compliance. All of you that may be starting new jobs soon, you know what, this is a great way to start. Like, we have this requirement. Are we meeting expectations? Audit your compliance and create the evidence that you are. So that is the end of patient access. I just want to open it up to questions again. Does it make sense to you? Do you have any clarifications?